Victoria Law Judges and a convener of that association's Human Rights Nexus Working Party. Before she went to the bench, Catherine Branson practices as a barrister at the Adelaide Bar. She's speaking to us today about the topic of enhancing equality, reforming anti-discrimination laws to make Australia fairer. She's perfectly placed to set the scene for today's conference and contextualise the development and promise of federal government's consolidation project. Please join with me in welcoming Catherine Branson.
Thank you very much, Anna, and could I start by thanking not only Anna for her kind introductory remarks, but also Auntie Di for her welcome to country, and I acknowledge her fellow elders, her mother, her grandmother, as traditional owners of the land on which we meet, and all the Wurundjeri people. I pay my respects to all their elders past and present, and also to those members of the Aboriginal and Torres Strait Islander peoples who are with us today. In fact, I acknowledge everyone here today, really fellow workers for human rights in Australia. On behalf of us all, let me also thank our hosts, RMIT, and the Human Rights Law Centre as conveners of this conference. And like Anna, I thank the Attorney General of Australia and his department for supporting the Human Rights Law Centre in facilitating public debate and other input on the process of consolidating federal discrimination laws, this very important part of the human rights framework. The Consolidation Project, as you know, is part of that important framework, and it was announced by the government last year in response to the National Consultation on Human Rights. It's no secret that people in Australia concerned about human rights protections, including the Australian Human Rights Commission, didn't see everything that we hoped to see coming out of that report following the national consultation. But we did see in the government's response some very important initiatives, opportunities to progress human rights protections in our country. So we have provision for improved parliamentary scrutiny of legislation, including human rights impact statements, so at least we have part of the dialogue model that those of you who are in Victoria have become familiar with. And that will be put in place, importantly, at the federal level. Scrutiny will be undertaken by reference to all of the principal human rights instruments, perhaps with the exception of the Slavery Convention. And so it's not just a more restricted list of rights which many thought that it might be. So this will provide a challenge to us, as well as an opportunity for improved transparency in law in policy making, and thus one trusts improved respects for human rights in Australia. Development of a new Human Rights Action Plan, including implementation of the commitments made during Australia's Universal Periodic Review in the Human Rights Council in Geneva, is another potentially significant part of the human rights framework. The Action Plan process offers opportunities for a comprehensive stocktake and benchmarking of the status of human rights in Australia, for setting targets for progress over the life of the plan, and for the taking of actions to reach those targets. A draft baseline study is currently out for public comment, and a draft of the action plan itself will be available later in the year. I encourage everyone here to involve themselves in the process, including through the website hosted by the Human Rights Law Centre. I also urge everyone to press the targets and actions for progress towards equality to feature prominently in our Human Rights Action Plan. The National Human Rights Action Plan offers an opportunity to put the pursuit of equality and other areas of human rights protections on a better footing. So this brings me back to today's programme. A process of review and consolidation of federal discrimination laws could be seen as a fairly technical and limited exercise. Review and consolidation of existing laws sounds less ambitious and less exciting than language such as development of a comprehensive Equality Act. But the Australian Human Rights Commission is approaching this exercise from the perspective that this is not a purely technical exercise in tidying up and simplification. And we believe that the process does offer real and important opportunities to see how discrimination laws can contribute more effectively achieving equality in our society. I should point out immediately that the Commission has not at this point adopted formal positions on the details of the legislation that should emerge from this process. I'm sure that our views will continue to benefit from discussions by academic and other experts and interested parties today and as the process develops. But I think that there are reasons to approach the process with a fair degree of ambition and expectation. That applies both to the grounds of discrimination which the law should cover and how it should work to eliminate discrimination on those grounds. In relation to the grounds of discrimination covered, while the government has referred to consolidation of existing discrimination laws, which might be understood as referring only to coverage of the racial, sex, disability and age discrimination acts, it has also referred to developing a single comprehensive law. Election commitments were made with a welcome degree of cross-party support to include at least the grounds of sexuality and gender diversity within this process. It would seem sensible and necessary to look also as a minimum at those additional grounds covered by the Fair Work Act and by the Australian Human Rights Commission Act, at least so far as employment is concerned. Of course, coverage of these additional grounds should not be assumed as an automatic result of the consolidation process. Arguments may need to be addressed about how placing additional obligations on employers fits within an exercise which is also about reducing regulatory burdens. Part of the answer to this, I suggest, may be that there would be little, if any, increase in substantive obligations, including these additional grounds, within a single federal discrimination law, given their coverage, in most cases, by the Fair Work Act at the federal level, and in some state and territory laws. Also, that overall regulatory burden could in fact be seen as diminished by having a clearer and more consistent regime for employers to deal with. Simplicity and consistency in legislation is not only a benefit to judges, lawyers and law students, but also to people trying to understand the law in order to comply with it. Objectives of streamlining federal anti-discrimination law and addressing current inconsistencies between the acts, making the system more user-friendly and reducing compliance costs by clarifying rights and obligations may be mainly about efficiency. But in announcing the process, the Attorney-General and the Minister for Finance also emphasised increasing the effectiveness of discrimination law in achieving the objective of removing barriers to equal participation in society with consequent economic and social benefits. Legislative clarity is itself an important compliance strategy. Legislation is likely to have greater effectiveness as well as efficiency the more readily its terms are able to be understood and explained without resort to judicial or legal interpretation. The amount of recourse to the courts to date to ascertain the meaning of basic provisions in federal discrimination laws has been disappointingly high for what are meant to be beneficial laws. Disappointing because resort to superior courts for interpretation is expensive to the parties and to the public. Because lack of clarity in the law leading to this level of recourse is likely to have limited the degree of voluntary compliance occurring and increased costs of seeking legal and related advice. And in several basic respects, such as identifying the elements of direct discrimination, the courts have not left the law appreciably clearer than it was before being subject to judicial interpretation. As a former judge, I'm allowed to say. So an opportunity to improve the clarity of the law is welcome, and there are some obvious areas for attention. First, the complex and inconsistent definitions of discrimination, the array of different exceptions and different areas of life covered or not covered under the different acts, and gaps and inconsistencies between the acts in the mechanisms providing for